and thank you, Neely. I've never heard actuarial detail so gripping. Amazing. It was wonderful. We'll take questions now. To the degree possible, please address your questions to a specific person here, but if not, we'll find an answer. So anybody?
Just a quick question about which states do have the power to regulate and how come California doesn't?
There's a slight difference of opinion as to which states do and don't have the power to regulate, because there are various loopholes or exceptions, etc. Mila mentioned that Maine has prior approval authority, but only in the individual market, not in the small group market, so it varies. But there have been a couple studies. The National Conference of State Legislatures says 26 states have the authority. The Kaiser Family Foundation bumps that up to about 34 or 35 plus DC. And the difference is simply whether or not we're talking about both the individual and the small group market, whether we're talking about only HMOs or only nonprofits get regulated, et cetera, but that's the range.
And California doesn't have it because
well,
we just never...
It was never enacted.
Never an issue.
Well, not that it was never an issue, but efforts we have tried in California, and Harvey can talk to this as well, for 5 years to get that sort of regulation passed.
Question right there.
Yes. My name is Amy, Senator Hatch's office. This question is from Nila. So a lot of the impact of rate reviews on the individual market, the slide that you have on the dividends, I know that you said that those were overall dividends. What should this tell us, given that most of the impact is going to be specifically in the individual market in terms of how much profit that they are able to still make? Do you have any sense of how that?
Thank you for that question. Our individual market is relatively small. I think it's at most 6% of the largest carrier's business. If you'd like the individual market reported profits, it is for the largest carrier on our website for their 2011 filing. And so you can see most years the individual market itself has been pretty profitable. In terms of what that slide tells you, Maine has had guaranteed issue and adjusted community rating protections in both the individual and small group market for many years. And one of the myths out there about ACA is that because of the new rate reforms and access requirements, that will shut down markets. That's just not the case. Companies in Maine have been operating in a very, I would say, profitable way for many years under the kinds of protections that ACA now puts in. So that slide really tells you a number of different things, including the fact that the for-profit industry can exist in a market with significant consumer protections and regulatory oversight.
Sarah?
Yeah, hi, I'm Sarah Cliff with Politico. I was wondering just for Harvey, if you could speak a little more to the intervener provision of 103, and my understanding is it's also similar in AB 52, and how kind of how you have all been involved as an intervener and how you see that playing out with the regulation of the health insurance industry.
Well, so any citizen, the statute says that any citizen, any consumer can intervene in any proceeding before the department or even in a court proceeding to challenge any violation of Prop 103 or any rate application. So over the years, I guess obviously because of our disposition to a relationship towards Prop 103, we've sort of been the leading organization on it, although over the years since the passage in 1988, a number of other organizations have intervened as well. And what we found is that it's well, let me just step back a second. So the insurance commissioner, which 103 made an elected post, not an insignificant part of the overall reform, the insurance commissioner promulgated regulations that govern not only the prior approval process and the approval of rate applications, but also the intervener process. Everything very carefully and extensively vetted by industry lawyers as well as consumer groups. And under the intervener rules, we petitioned for a hearing. And if the rate increase is for a home or personal lines insurance business, and it's over 7%, and we request a hearing, it has to be granted. 15% for commercial lines. And so 9 times out of 10, the way we achieve the savings that I spoke of and that the report describes is that we go in there, we point out the fact that the insurer's application doesn't comply with the regulations, that they've jiggered the numbers, they've tried to ask for amounts that they're not entitled to under the formula. And like I say, 9 times out of 10, either the company withdraws the application on the spot, or there's some wrangling or quote negotiations. The report discusses in detail a big challenge that we leveled against Allstate, which they ended up refunding and lowering rates by hundreds of millions of dollars. Occasionally, once in a while, these things go to a full-fledged hearing, and it's an administrative hearing with, it's not a court hearing, but it's an administrative hearing with lots of protections. It looks a lot like a trial, and it's the insurance industry's lawyers and actuaries and experts against our lawyers, actuaries, and experts, and you won't be surprised to learn that there are a lot more of them than there are of us, but we still do pretty well. And then at the end of the day, under Prop 103, if we make a, quote, substantial contribution to the outcome of that proceeding, then the commissioner can order our fees and expenses be paid. The substantial contribution standard also protects the insurers in this sense that we can't do duplicative work. We can't go in there and play games or do nothing and then collect our fees and expenses. We have to make a substantial contribution to the outcome. Does that answer your a little more? Okay.
Any other? Yes.
Sean Carr with Best Week Insurance News. Harvey, last year when the prospects for the Affordable Care Act were at some of their lowest, Anthem Blue Cross went ahead with and proposed a giant increase, which helped add fuel to the cost for the Affordable Care Act.
Mm-hmm.
And as this bill is being considered in California, Blue Shield of California proposed another massive increase.
Right.
To what degree is that helping you make your case?
You're asking me to sort of assess the legislative prospects. Obviously, it's helpful. This is an uphill battle, however. I'm a little more pessimistic than my colleagues at Consumer Watchdog, maybe, but I'll just tell you that. And these guys are very good at what they do up in Sacramento, but I'm a little concerned that as in 1988 with Proposition 103, when we brought the bill first to the legislature in a much more modest form, Prop 103 went nowhere. So I'm a little concerned that the legislation may again fall victim to the prowess of the insurance industry. However, the outrage of what's going on in the markets, particularly for individual Blue Cross Blue Shield customers in California, is so great that I can only liken it to the sense of revolt that occurred back in 1988 with auto and home insurance rates, and that's the reason why we spent $2.9 million on the Prop 103 campaign, and the industry spent over 60, and we beat them. It was a David versus Goliath battle, but they lit the fuse themselves, and ultimately I think they bear the responsibility for the passage of the measure. And here I think that on the national level, the sort of political scenario is this: there are institutions like the insurance industry, the Chamber of Commerce, other lobbying groups, and certain portions of the ideological spectrum that are going to take a look at what's happening to premiums if they are unregulated. If they remain unregulated for healthcare, they're going to say, "See, it's government's fault." But then they're going to be, and that's the analogy to what the industry did back in 1988 when they tried to blame everything on the trial lawyers. There's going to be us and a lot of other people talking to the consumers and the voters' instinct, which is, I'm getting the bill from the insurance industry. It's not government's fault. It's the insurance industry's fault. So that builds the public campaign for reform, either in Congress or at the ballot box.
Can you give me the status on the viewer bill? I mean, where it's at right now?
It is.
It passed its first legislative hearing, its first policy hearing in the Assembly, and it's moved on to appropriations. I don't think there's a date set for that.
On the Assembly side.
On the Assembly side still.
Yes, the mayor. you speak up just a little?
Sure. Hi, I'm Amy from Inside Health Policy. It's my understanding that the providers are also against the AB 52. Can you discuss why?
Well, I can give you my thoughts about it. In 1988, even though Proposition 103 applied to doctors and businesses, and in fact, as I mentioned, the only time doctors ever got any rate relief, despite the passage of the CAPS law 10 years earlier, was when 103 passed, and their premiums went down by an average of 20%. But yet all these groups opposed Prop 103 I think just for ideological reasons or their connections with the insurance industry. And I think what you're looking at when you see the California Medical Association oppose health insurance regulation, you see the influence of Kaiser and other insurance companies on the California Medical Association, which in my perception, just like the AMA, reflects or represents ever fewer numbers of actual doctors in California. So I don't think the California Medical Association and all their allied, kind of commingled business medical industry groups are really reflective of what most doctors in California think, which is that they've been run to ground in the industrialization and privatization of healthcare. That's why most of them went to med school.
Back, yes.
Sure, please, and I'd love to hear from Maine.
Yeah, it's been really interesting. I hold hearings around the state to give people an opportunity to weigh in. And at a number of the hearings, we've had physicians, their managers of their offices, as well as other medical professionals come testifying against the rate increases for a number of different reasons. So certainly the experience in Maine hasn't, there's no real evidence that, there's no evidence that I can point to that shows that because of the rate review process, somehow that hinders the ability of doctors and other medical professionals to practice and get paid for the services that they provide.
Good on the ground. Yes.
Kathy Hurwitz with Janchkowski. And first of all, I want to thank you for holding this. She is very sorry she can't be here. We're discussing medical malpractice insurance reform over in the House. I wanted to ask, particularly Harvey, one of the things that we're seeing in Illinois is a lot of people assume that the insurance department has regulatory authority to block unreasonable rates and to order rebates. And when they find out that they don't, they're quite upset about it. And that's particularly true for small business. And I think the small businesses that we're finding in our state, their views aren't necessarily reflected by the chamber and NFID here. Did you work with small businesses in passing Prop 103? And did you do an education effort just to even let people know what the status of the authority was?
Well, it was pretty clear that there was no regulatory authority. I mean, it was unmistakably clear in California that there was no control over the premiums because they were going through the roof. It's a little bit like my answer to the last question. The organized business community tends to favor, even if they claim to speak for small business like the chamber does. They're really always representing big businesses. Small businesses and physicians are among the greatest beneficiaries of Prop 103. But we didn't have a lot of we had none of their organized support. We had a lot of small businesses, individual proprietors, sole proprietors, or small companies that were supportive. The big companies were all corralled by the powerful industries, connections to the lobbying forces, and they all opposed. But I think it's fair to say everybody knew that there was no regulation of rates. People were not confused about that. That was one thing that was clear.
People in Illinois, people think that the rates are really going high, but that somebody's checking off on it.
Yeah.
And they don't realize that nobody has that authority.
I guess, well, that would be step one of the public education campaign.
And I would just add to that is really a key part of our argument that in order for the health reform law to be successful, states need rate regulation because the public believes that there's a new law in place that's holding down these rates, and it works in some states. And in other states like Illinois, there's no authority like that. And in order to defend the Affordable Care Act, states need the ability to really scrutinize what health insurers are charging, and under the current law, they don't have that authority in all cases.